So the Supreme Court on Monday, which is on uh, in rule that bail granted under Section 167 of the Code of Criminal Procedure can be revoked even if the investigation agency failed to complete the investigation and file a charge sheet within the given time frame if the accused has committed a non-bailable offense and a strong case is made out of the odds that are against him. So the court noted that an accused granted default bail cannot claim special rights to remain on bail. The court allowed an appeal by the CBI against the Andhra Pradesh High Court's judgment, in which the plea to cancel the default bail granted to T.Gangi Reddy, who is accused of murdering Y.S. Vivekananda Reddy, who is a former minister and also the uncle of present Andhra Pradesh Chief Minister Y.S. Jagan Mohan Reddy. So the court ruled that it was appropriate to remand the case to the Telangana High Court to consider the merits and benefits of whether bail should be revoked in this particular case. So in our situation, the court, however, also stated that the mere filing of a charge sheet is not sufficient to cancel the bail, and this action should only be taken where there is existence of special reasons besides the fact that uh, a commission exists of non-bailable crime. The bench noted that the liberty of a suspect released on bail cannot be the subject of intrusion and interference merely on the ground of the prosecution and uh, and the fact that it has submitted a charge sheet as it would introduce a sense of complacency in the investigation agency. The court also observed that the bail should be cancelled only when the accused deserved to be in the custody and not on merits or general grounds like not cooperating with the investigation agency, tampering with the evidence or witnesses, or not cooperating with the concerned court. And in this case, uh, Mr. Reddy was also found to have been in a situation where he was threatening the witnesses. So there's that. The cancelling of default bail could be ordered considering the grounds set out in Section 437, Clause 5, and Section 439, Clause 2 of the CRPC if the defects for which default bail was granted were cured or special or strong reasons are made out from the subsequently filed charge sheet that the accused has committed a non bailable offense. So that is my analysis. Thank you.
So, so this is the case wherein the CBI is the appellant and the Ganji Reddy or Yerra Ganji Reddy to be precise is the opposite party respondent here who is in bail as per section 167 clause 2 of the CRPC, which is a default bail of which according to CRPC one gets when the police is or the investigation agency is not completing the investigation vested upon it, constitutional duty, the statutory or constitutional duty vested upon it when it defaults, then the person who is in custody gets bail as per section 167 clause 2 for offences of murder, life imprisonment, or an offence which entails a punishment of not less than 10 years, then that person is and is can be arraigned into custody for 90 days, and for any other offence, it is 60 days. So nowadays, the court is much uh, inclined upon giving bail as a kind of a constitutional right. So in the present case, also the same question of bail happens. So in the previous various cases like Satyendra Kumar, etc., we have seen that for offences which has punishment of up to 7 years, or the arrest is to be power of arrest has to be exercised cautiously, taking into circumstance various issues, and the person is entitled for bail. And even after filing of the charge sheet, also, if the person happens to not being arrested, then also the person shall not be arrested. That was the observation in the Satyendra Kumar case. So bail is what the court is pushing in almost every case that we discussed earlier. Present case also presents a different scenario wherein we have this appellant CBI asking for cancellation of the bail which was given to Ganji Reddy. The Ganji Reddy was arrested by the police, the special investigation team, for death of an MP and MLC on March 19, and he was charged with Section 302 IPC and 120B criminal conspiracy. Later, he was remanded to judicial custody. Statutory period of 90 days elapsed on 26th of uh, June of 2019. So he applied for bail as per 167 and he got the bail. This is the story. Now, after there has been allegations of various petitions was filed with the High Court, and there was allegations of tampering with the evidence or undue influence over the witnesses, etc. The investigation was given to CBI. Now, when we and the impleading party in this case was the daughter of the deceased MLC, that is daughter of the daughter of the person who died. And so CBI took up the investigation. Now, CBI went through various aspects of this case, started investigating, and filed a preliminary report. And based upon which CBI asked for before the special court of CBI, as per Section 439, Clause 2, for the cancellation of the bail given to the accused. So the trial court, with order dated 30th 11 2021, dismissed the order. The CBI filed a subsequent supplementary charge sheet under Section 201 and 120B, read with Section 302 and 201, arraigning accused 5 and other accused also in this present case. And the CBI filed criminal petition before the High Court under Section 439, Clause 2 for the cancellation of the bail. High Court also dismissed the application by saying that bail cannot be cancelled on merits. So the question now before which erupts before the Supreme Court is whether the circumstances, what are the circumstances under which bail can be cancelled? First thing. Secondly, whether bail can be cancelled on merits having found the accused have committed non-bailable crime on conclusion of the investigation and filing of the charge sheet. Now, I would like to, at the first instance, I would like to say that in Vikramjit Singh versus State of Punjab, which I found in the website of Supreme Court which is the citation is 2020 10 SSC 616. It has been said that Section 167 Clause 2 CRPC is a fundamental right and not merely a statutory right, as it is a procedure established by law under Article 21 of the Constitution. So now we come across the situation that
ആ
Section
കേസ്
1.
ഒന്ന് ആ കേസ് ഒന്ന് കോർ ഗ്രൂപ്പിൽ ഇത് കഴിഞ്ഞിട്ടൊന്ന് ഷെയർ ചെയ്യണേ.
Okay, sir.
ഓക്കെ.
So that particular case and gives the constitutionality to constitution aspect or a phase of utmost importance to Section 167 Clause 2, wherein it, it, it puts the Section 167 Clause 2 at a higher pedestal, equating it to Article 21, that is life and personal liberty. Now, after having seen the submissions made by various parties here, we come to the conclusion that CBI won the case. CBI has put on the famous case of Aslam Babalal Desai versus State of Maharashtra, which clearly points out that on special ground being made out that the accused has committed very serious offense, that is committed a non-bailable crime, and he deserves to be in custody even in a case where accused is released on default bail under Section 167 Clause 2 of CRPC, his bail can be cancelled. That is, after filing of the charge sheet, if it is found that he has committed a non-bailable crime, then he is not entitled to be in scot-free. He has to be booked and he has to be in the jail. That is what Aslam Gabal al Desai points out. The grant of default bail under Proviso 2 of Section 167 is deemed to be real release in terms of Chapter 33 of CRPC. And that Chapter 33 of CRPC also provides for Section 437 and 439 of CRPC, which gives the court the right of taking away uh, the power of taking away the right of bail also. And in also, we have seen in another case which was pressed by the CBI side was Abdul Basit alias Raju versus Muhammad Abdul Qadir, in which it has been stated that bail under Section 167 Clause 2 of CRPC can be cancelled on an application by the prosecuting agency. And now, on behalf of the respondent here, it was vehemently said that mere subsequent filing of charge sheet cannot be a ground to cancel the bail granted to the respondent under Section 167, Clause 2 of CRPC. That is merely if you charge sheet, put an additional charge sheet also, you cannot take away the right. But that was totally destroyed by the famous judgment in Aslam Babala Desai itself, which states that even though the charge sheet has been filed, if you have some cogent material which gives grounds for cancelling, that is, if there is something cogent and special and strong ground is there, that there is a commission of non-bailable crime which is disclosed from the charge sheet itself, that the bail can be returned. It can be cancelled, and so you cannot ask for bail. So it always you corner around the particular charge sheet and the sections involved and the severity of the crime that you've done. So this case can be a case of precedent also, but it has to go into various merits of the case and the circumstances in the charge sheet. So magistrate has to look upon the circumstances mentioned in the charge sheet, and if he is of the opinion that this case is a case which warrants further detention and cancellation of the bail, then he is at liberty to do that. That is what this case totally puts in. So the grounds for yes, first question is answered before the Supreme Court. That is yes, the bail can be cancelled. Second question is, what are the grounds? Which was mentioned in Ranbir Singh and others versus State of Bihar. Then in paragraph 22, that is, wherein bail can has which has been granted under Section 167 Clause 2 on default of non-completion of investigation in 60, 90 days, etc., can be cured mm, by filing of the charge sheet, and the prosecution may seek to have the bail cancelled on the grounds that there are reasonable grounds to believe that the accused has committed a non-bailable offense and that it is necessary to arrest him and commit him to custody. So, what has to be proved is reasonable grounds. What are the reasonable grounds? Number one, to believe that the accused has committed a non-bailable offense. Number one. Number two, it is necessary to arrest him and commit him to custody. So these two grounds has to be proved before the magistrate, and if the magistrate is satisfied with these two grounds, yes, for these power under 437 it can be used, and 167 clause 2 bail, which is granted to the accused, can be cancelled. So this judgment is collating almost every other judgment that we found, and it can act as a precedent, and it gives magistrate more kind of judicial discretion to check into the various facts and merits of each case. And but at the same time, as I said in Bikramjit Singh also, this dilemma persists. That is, the 167 clause 2 is equated as a not as is a fundamental right, and not merely as a statutory. Then I don't know whether this judgment will fall in the correct place. But yes, due appreciation must be given to the fact that if he has committed a non-bailable serious crime, then he has to be booked. Yes, but I believe it has to be come after the trial. That is, if after the trial, if it is convicted, then okay, bail may be cancelled. But till then, I believe bail has to be the main, it has to be constitutional right, because as Gino sir has correctly pointed out and mentioned by Justice K. Ramaswamy, that is, uh, Justice Ramaswamy concurred with the decision of Justice M. Panchi in Aslam Babulal case. That is, it might be possible that the abuse of Section 167 Clause 2 CRPC can be used by the investigating agency. So, on putting all these in a triumvirate, I think, uh, yes, judicial mind has to step in in this particular case, and it is the discretion of the magistrate, and various elements or each case has to be decided on its own merits. That's what I believe and I understand from this case.